Good evening, friends. And as they say that the vacations are on the onset, it's the first day in Punjab and High Court. Whereas in Karnataka, vacations are come to an end. We thought, why not take a topic which especially the youngsters would like to understand, that why their civil cases fail and what are the lessons you can learn from the courtroom, which are what they say practical perspectives are always different than what you learn in the books. Therefore, Beyond Law CLC and Curriculum Associates requested Mr. Ameet Deshpande, who is a senior advocate, to share his insights in this perspective from his vast experience. He needs no formal introduction as such, since he has done various sessions with us. I would request Mr. Trivicrum to share his thoughts and then over to Ameet.
Good evening, all of you. I'm extremely sorry. Firstly, I'm not well. Secondly, it's pouring here, cats and dogs. So I think there's a lot of network issue as well. I'm also a very enthusiastic participant today to listen to senior advocate. We are all not interested in having only paper decrees anymore. So where we fail is what even I want to know as a practitioner. So over to you, sir. As always, we have a lot of fan following for you. And I'm also one of those fan followings. Over to you, sir.
Namaste. Thank you, Mr. Vikas Chatrat, Senior Advocate. Thank you, Mr. Trivikram. A very good evening to all of you. Namaste sabhi ko. Congratulations, Mr. Trivikram, for seeing rains in this hot summer. I come. So, if I am permitted to share my screen, I have few slides to show, just for the purpose of the audience to know it with more clarity. This topic is, in fact, a very interesting topic even for me. It is interesting because it reminds me of the mistakes which I have committed. This topic probably is more relevant for all those advocates who have been committing mistakes, who had committed mistakes, because I don't feel there is any advocate who would say that one has never committed mistakes at all in conducting a litigation. We always have a feeling that we could have always done better. If you all remember what the great jurist and legend F.S. Nariman had once said, that there are three times when the arguments are made by the advocate. One, when he sits in the office and prepares notes for what he wants to argue. Second, when he actually argues those points in the court hall, which would be something different, less or more than what he had noted sitting in the office. The third one is when he comes back to the office after the arguments are over, and then he realizes what more, what better one could have argued. So these are the three types of arguments that one makes in each case, is what the great jurist had once said. That only is more relatable to me, at least, where I feel I have few points noted today. I argue few other or some less points in the courtroom. And then when I come back, I feel that I should have added more to my arguments. Can I now share the screen?
I think now it's enabled, sir. You can.
Yes, yes. Is it now visible?
It is visible, sir. So just make it as a slideshow.
Yes. I don't know whether I am visible to any of you.
You are also, there is one option, if they can make it on the side bar, they'll be able to see you. I'm able to see both of you.
No problem. I am not able to see myself. Nonetheless, I'm not so keen to see myself also. I'm happy if you people hear me more than see me. So the topic today is why civil cases fail, lessons from the courtroom. Dear friends, these are only few experiences which I have gained from my own mistakes, which I have gained from observing in the courtrooms, which I have gained from knowing what others have told me, what they assume are mistakes. This is not a compendium, an exhaustive lecture. Therefore, please keep in mind that these are only few insights which I have. You people can take some clue from this, relate to the improvements that you can make. So let me start from the first slide. In the life cycle of any civil case, the first thing that one has to keep in mind is that once a client comes to you, to your chamber, it is for you to decide what relief exactly your client needs. For that, you need to know who is the one against whom your client has to seek the relief. Most often, confusions, I can say, if not mistakes, occur when we as advocates sit in our chamber while preparing the brief, while client counseling sessions happen, while we draft the pleadings. At every stage in a civil case, there is one mistake which we feel we should not have committed, which we realize sometimes and many times after the case is over. So firstly, my dear friends, please remember, when should we file a case at all? In a civil case, any seasoned lawyer who I have come across has always told me that it is wiser for an advocate to ensure that he doesn't go, rather his client doesn't go to the courtroom being a plaintiff. It is always essential to understand that the plaintiff carries more burden to prove his case rather than the defendant in the same case. Therefore, the first thing that one has to keep in mind is, unless there is a serious threat to one's right that it becomes unavoidable to file the suit, being a plaintiff in a case is to be avoided at any cost. One should wait until the opponent chooses to make the first move of filing the case. As I have told earlier, it is easier to defend the suit rather than to succeed to persuade the court to pass a decree granting the reliefs sought for by the plaintiff. Remember, we all come across clients who are very enthusiastic, anxious to say that, sir, I have a cause now. There is a threat right now. Most of the times, the threat is only a misconceived, perceived threat, an apprehension mere, and not a real threat which gives rise to a real cause of action. So we as advocates, with our experience, must be having that wisdom to decipher the perceived apprehension in the mind of the client that his right might get affected and the actual apprehension that his right is getting affected, for which it is necessary that one must go to the court and seek redressal. So therefore, remember that every little perceived threat need not necessarily always create the cause of action for a party to actually file a suit in the court of law. If we make the first move only on the assumed little perceived threat of your client, then probably we will be shouldering a heavier burden throughout the journey of the litigation of that client at every stage to prove or to disprove his case or disprove the opponent's case. So that shouldering of a heavy burden is required to be avoided. Subject to all just exceptions, generally it is stated that the burden of proof of the case always rests on the plaintiff, though the onus of proof may shift from time to time. The burden of proof on the plaintiff is heavier than the onus of proof on the defendant in the suit. This is one thing which we must all remember. Most of the times we make a wrong choice of being a plaintiff, and therefore we find ourselves in a soup where in the later stages of the suit we will be unable to easily prove the facts which we want to rely upon for persuading the court to grant the relief and pass a decree. There is a Latin maxim which explains this concept more clearly. The maxim reads thus: in pari delicto potiores conditio defendentis or conditio possidentis. This is also equally true when we also read the concept of title follows possession and the other concept of possession follows title, where a person who is in possession, in jurisprudence, we also read possession is 9 by 10 or 9 out of 10 points in law. Same way, in pari delicto, potior est conditio defendentis or possedentis means that when both the parties are at fault, then law would rather prefer the person who is in possession, or the law would rather prefer the defendant in the suit to be in a better position. This is applied in several other circumstances also, but I found it to be more apt in this situation to explain it to you why one should not be the plaintiff in a suit if it can be avoided, and rather choose to be a defendant. If both the plaintiff and the defendants are put to test in the trial to prove and disprove their respective cases, if no party leads evidence, then the outcome, the necessary outcome will be that the suit of the plaintiff will be dismissed. It is not that because the defendant has not been able to prove his case, the plaintiff can gain something from the weakness of the defendant. This will not be allowed in all normal circumstances. Therefore, in pari delicto, potior is conditio possedentis or conditio defendentis means when both the parties are at equal fault, the defendant or the person in possession is in a better position in any given case. It is well recognized principle also that the plaintiff has to either win or lose on his own strength and cannot succeed merely on the weakness of the defendant. Let us read section 102 of the Evidence Act. It says on whom burden of proof lies. It says the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Of course, there are illustrations which clarify this more. I will read the illustration also so that one can understand this provision in a better way. Illustration A says, A sues B for land of which B is in possession and which A asserts was left to A by the will of C, B's father. If no evidence were given on either side, B would be entitled to retain his possession. Therefore, the burden of proof is on A. Another illustration, A sues B for money due on a bond. The execution of the bond is admitted, but B says that it was obtained by fraud, which A denies. If no evidence were given on either side, A would succeed as the bond is not disputed and the fraud is not proved. Therefore, the burden of proof is on B. This is how the provision explains. There's one more provision in the Evidence Act which would be relevant for this purpose. Section 101 of the Evidence Act, which is dealing with burden of proof. When I'm speaking about the burden of proof being very important, and therefore one should always ensure one doesn't go to court as plaintiff. One should know, the advocate must know what is burden of proof, the concept of that. So burden of proof is defined as whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. One of the leading judgments which has explained the distinction between burden of proof and onus of proof, which has explained what is burden of proof, is in the case of Anil Rishi versus Gurbaksh Singh, reported in 2006, volume 5, Supreme Court Cases, page 558. One of the paragraphs mentions thus, a distinction exists between burden of proof and onus of proof. The right to begin follows onus probandi. It assumes importance in the early stages of a case. The question of onus of proof has greater force where the question is which party is to begin. Burden of proof is used in three ways. One, to indicate the duty of bringing forward evidence in support of a proposition at the beginning or later. Two, to make that of establishing a proposition as against all counter evidence. And 3, an indiscriminate use in which it may mean either or both of the others. The elementary rule in section 101 is inflexible. In terms of section 102, the initial onus is always on the plaintiff. And if he discharges that onus and makes out a case which entitles him to a relief, the onus shifts to the defendant to prove those circumstances, if any, which would disentitle the plaintiff to the same. This is a very interesting judgment which has explained this concept of burden of proof, onus of proof, and shifting of the onus from one party to the other at different stages of the case. One can in detail read several judgments covering this aspect about burden of proof and onus of proof, and how the burden of proof or the onus of proof loses its significance if both the parties have led evidence in the suit concerning the issues of facts in that suit. That's another study, another topic for the study of all the audience here. Now, the next stage I had already stated. One is that we should not rush to file the suit merely because the client has assumed that there is an urgency or a need. Next, if at all we have to file a suit as a plaintiff, then the most important and the first mistake that we sometimes make, and most of the times repent for doing that mistake, is not choosing the right defendant or choosing more than few right defendants. So the first tip one can take from the mistakes which have happened in the past is choosing the right defendant or opponent. You all know, gentlemen, even in the book Art of War by Sun Tzu, he says, one must know who he wants to fight against. And once you know your opponent, then half of the battle is won. So strategy requires you to know who all stand between you and your right. So ensure you choose the right enemy, the one who is the precise obstacle between you and your right. One must be very meticulously assertive in naming the exact person who is necessary for the proceedings to be added as defendants. Failure to add all the necessary and proper parties as defendants might lose the cause itself. You must also be aware at this stage who is a necessary and a proper party, as law mandates and permits only the necessary and proper parties and only them to be added as defendants in the suit. An unnecessary party added as a defendant might burden the plaintiff more and also create an opportunity to the real defendant to fight in disguise. Failure to add necessary parties and adding unnecessary parties to the suit will render the plaintiff defective and might entail dismissal of the suit. Provisions of Order 1 of the Code of Civil Procedure 1908 will be very relevant. I'm sure all of you have, of course, read CPC and all the details of the Code of Civil Procedure. Nonetheless, for those who still want to know what could be the mistakes, I assume that for choosing the right opponent, Order 1 is must, and that is a very important stage of the advocate's preparation before he files the plaint in the civil court. See Order 1 of CPC, especially Rule 10 thereof. This provision, Order 1, Rule 10 of CPC, is explained in a landmark judgment of the Honorable Supreme Court, a leading judgment in the case of Ramesh Hirachand Kundanmal versus Municipal Corporation of Greater Bombay and others. This is a judgment reported in 1992, Volume 2, SCC, page 524. Of course, the law has marched ahead of this judgment also. There are several other recent decisions of the Honorable Supreme Court and various high courts which have thrown more light on these aspects. Nonetheless, what has been explained in this judgment would be for the present sufficient to understand this concept. I will just read out one excerpt from this judgment. It cannot be said that the main object of the rule is to prevent multiplicity of actions, though it may incidentally have that effect. But that appears to be desirable consequence of the rule rather than its main objective. The person to be joined must be one whose presence is necessary as a party. What makes a person a necessary party is not merely that he has relevant evidence to give on some of the questions involved. That would make him a witness, a necessary witness. It is not merely that he has an interest in the correct solution of some question involved and has thought of relevant arguments to advance. The only reason which makes it necessary to make a person a party to an action is so that he should be bound by the result of the action and the question to be settled. Therefore, must be a question in the action which cannot be effectually and completely settled unless he is a party. The line has been drawn on a wider construction of the rule between the direct interest or the legal interest and commercial interest. It is therefore necessary that the person must be directly or legally interested in the action in the answer. That is, he can say that the litigation may lead to a result which will affect him legally. That is, by curtailing his legal rights. It is difficult to say that the rule contemplates joining as a defendant a person whose only object is to prosecute his own cause. I have quoted this judgment because incidentally, when I am telling you about the importance of choosing the right person to be arrayed as defendant and not choosing the persons who would not be necessary to be arrayed as defendants, these principles are required to be taken note of. This will take a long way. This will take us a long way in explaining to the court in our own understanding of how the parties should be arrayed and should not be arrayed. The next stage, after we choose to file a suit or not, after we choose to be a plaintiff or defendant, after we choose to file a suit and then identify the real opponents and only add them, the necessary and proper parties as defendants in the suit, the most important part of the litigation is pleadings. Pleadings is defined in the Code of Civil Procedure, in various rules of practice of different courts, to be plaint and the written statement, and also it is defined as the applications or petitions and the other memorandum of appeal and revisions. Nonetheless, for the present, we need to understand pleadings from the perspective of plaint and written statement. First and very important aspect of my observation in the courts is, please remember, and there is no offense to anybody here when I say this, that the most effective way of communication is when we are employing simple sentences in English. If we are in the habit of using compound sentences, complex sentences, and then if we bring complex and compound sentences in our draft, in our pleadings, and file it in the court of law, that will be really attractive. Now that all of us are knowing English better than the earlier times, it will certainly be impressive also. But please remember, friends, pleadings are meant not to exhibit our skills of language, but it is meant for the parties to understand the case of each other. It is also especially meant for our own client to understand what he wants to prove in the case. If there is a very complex sentence, a very compound sentence which we make in the pleadings, then remember it is that party who is filing these pleadings in the court required to also step in the witness box and lead his oral evidence, depose before the court. He cannot go beyond what has been pleaded. And if we make it so complex, then how that person who is entering into the witness box is expected to explain his facts to the court in the simplest of the manner. Therefore, I want to say that employing simple language is mandatory. It is class in itself. Please use simple sentences in pleadings. Simplicity is the hallmark of class. Pleadings with great respect Pleadings are not meant to exhibit advocates' scholarship, extravagant knowledge, and rhetorics. It is meant and intended for the parties to seek relief, redressal, and justice at the hands of the court. It is meant for the courts to understand the real controversy of the parties. As I have stated, they are required to be proved by oral testimony of the plaintiff or the defendant and witnesses. Therefore, that party who is required to lead his oral evidence may not match up to the erudition, the rhetorics, or the linguistic skills of the advocate. Hence, this is the first mistake which we many a times commit. This not only is counterproductive to the litigant and the outcome of the case, but it also sometimes, I believe, burdens the court. Do not exaggerate and unnecessarily enlarge pleadings beyond what is essential. A lengthy pleading, exaggerated pleadings, unnecessarily explained repetitive facts in a pleading is not going to give any benefit to the litigant. The court, the judge probably would get exhausted in reading the same lengthy, unending pleadings. So sometimes we feel that it would impress someone more by giving more details or making it more lengthy or more attractive with flowery language. But then the purpose of pleadings, especially in a civil suit, may not be to only impress the court or the opponent or one's client or oneself. We also ultimately assess ourselves every day. We want to know that we are effective enough, we are impressive enough, and that's why we want to employ our linguistic skills under the assumption that these linguistic skills are going to become more effective. But then I think this is one mistake we commit. While impressing oneself, we try to unnecessarily go beyond the essentials. Therefore, please understand the fine distinction between what is required, what is essential, and what is still acceptable. I'm not saying that flowery language is unacceptable. It is still acceptable. It impresses, it attracts. Yet, if it is not essential, then it can be avoided. And this is very personal opinion of mine. All of you can still make an assessment of in your own way. Now, there is the next aspect of this. Please understand the distinction between the rules of pleadings in suits. What is required to be mentioned, what is to be pleaded in a plaint, in a written statement, is different from what is required to be stated in an affidavit, in a petition, or an application. Something else is required to be stated in a memo. In a writ petition, there are certain different rules which are required to be used. What is otherwise not permitted to be pleaded in a plaint or written statement is permissible when it comes to drafting a writ petition. For example, only it is mentioned that only facts are required to be pleaded and not law when it comes to plaint. Nonetheless, it may not be true, or it may not be mandatory that one has to only stop at narrating the facts while drafting a writ petition. In a writ petition, it sometimes, and most of the times, would be necessary to not only plead the facts, but also law and the interpretation. So therefore, there are different rules which are classically observed, followed while drafting plaints and written statements, while drafting affidavits, applications, and petitions, and writ petitions. We must understand the difference, the fine distinction between the rules of pleadings in all these different and variety of pleadings. One must be very, very cautious about this important aspect of pleading. Might be due to ignorance, might be due to the misunderstanding or lack of information, whatever could be the reason. any reason could hardly justify this act of an advocate. Do not, I suggest, advise and request, do not conceal any material information, any material facts in the pleadings. It is a mandate of law that one has to plead all material facts, all relevant and material facts. Therefore, forget not to conceal any material information in the pleadings. Do not suppress any material pleadings in the facts in the pleadings. Do not state anything. This is another aspect of the matter. Do not state anything that one cannot prove as per the provisions of relevant laws. Most of the times what we do is we start narrating the facts in the fashion of a story. And while narrating the facts in the fashion of a story, when we are calling it a story, then obviously there are certain assumptions, certain imperfect statements that we add into our pleadings. Certain statements which might be true also, but which cannot be perceived, which cannot be proved by the provisions of Evidence Act or any other statute which prescribes how evidence or how facts are to be proved. If we are aware that there are certain statements which the client insists or which we feel is relevant but cannot be proved at all, then please ensure that you make amends to that part of the statement, that part of the pleading. When it comes to written statement, the often mistakes we make is, which we must not make, is that we forget to make our denials specific and clear. We should not make this mistake. I'm sure, my dear friends, when I'm saying this, this is very rudimentary and fundamental to civil practice. All of you must be aware, all of you must be following this rule, that you will be making a very specific and clear denial in the written statement. Nonetheless, I am only repeating what one should not miss. If you have been following it, it is only a reminder to you that what you are doing is right. If you have not followed it, then please remember every time that a denial in the written statement has to be specific and clear. Do not falter in supplying, don't make a mistake of supplying unnecessary details in the written statement. Details with regard to that aspect of the matter which are not relevant to the claim made by the plaintiff in the plaint. If the plaintiff has chosen to rely upon certain facts and wants a certain relief from the court, then in the written statement, address only those facts which he is relying upon in the plaint for his claim, and only address and supply those relevant facts which are necessary to deal with the narration that he has made. Just because the defendant knows and has many things to say about the plaintiff, there need not be mention of all and sundry details in the written statement. Finally, one must understand, remember, that written statement is a pleading to answer the statements made in the plaint in relation to the relief. The defendant is not meant, written statement is not meant to record an eulogy of the plaintiff. It is also necessary to remember, like the defendant, like the plaintiff, the defendant also is required to discharge the onus of proving his pleadings. Therefore, if he is giving a eulogy in the written statement of the plaintiff, if he is simply narrating all that he wants to about the plaintiff without restricting it to the claims made by the plaintiff and the facts narrated in the plaint, then it will be very difficult for the plaintiff and his witnesses to prove those things in the court. Apart from the difficulty that the plaintiff will face, please remember the time of the court. If I, as a defendant's counsel, want to rely upon lengthy, unnecessary details of the plaintiff's story, which is not so relevant for the claim that the plaintiff is making, and I'm asking my defendant or witnesses of the defendant to step into the witness box and state all those which I have stated in the written statement, it will take a long time, and the opponent counsel will be taking even much higher time, longer time to address all those things in his cross-examination. So we sometimes commit this mistake by which we lose sight of the important aspect of the case. We also ensure sometimes by this unnecessary lengthy evidence and pleadings that the court also forgets what is the crux of the matter, where the controversy lies. Therefore, this is one important aspect of the matter. While drafting a written statement and filing it in the court, and please ensure that if a set off is required to be pleaded, please plead it. If a counterclaim is required to be raised, please raise it in writing at the earliest in the written statement itself. Please remember, courts may not always come to the aid of a person who has failed to raise a claim in writing when the opportunity was available. There are provisions under the code. You may make an amendment application, you may raise a counterclaim a little later. There are certain interpretations to that rule also, that you cannot raise it after if the cause of action has accrued to you after the written statement is filed, or after the issues are framed, you cannot file a written statement. All those interpretations are okay, but all that should be an exception. At the time of drafting a written statement, it should be our duty as advocate sitting in the chambers to ensure that we make the work as perfect as possible. And therefore, if a counterclaim, if the cause needs a written counterclaim to be raised in the written statement, it must be raised. This is something which we must keep in mind. Many of the times we find, after the journey of the litigation continues to a long stage, at some higher court, we realize that we should have in fact raised one set off or a written counterclaim, or we should have made some statement there in the written statement at the earliest, failure to which has now put us in a great trouble. So therefore, instead of rectifying mistakes which we have committed now and rectifying those later, it is this appropriate time when we should ensure that we take note of and take care of and be cautious at the time of preparing the written statement, the plaint itself. Remember, while the written statement is drafted, don't forget, remember to look into and specifically raise in writing all the technical aspects of law. For example, there might be an issue of limitation that you could have raised in the written statement. Please forget not to look into that aspect. An issue of court fees, issue about inherent jurisdiction of the court, issue about the territorial or pecuniary jurisdiction of the court. There could be a case where a statutory notice might be a prerequisite for the plaintiff to institute a suit. You have to take note of that requirement and point it out in your written statement that a statutory prerequisite is not followed or complied by the plaintiff. Maybe sometimes a statutory authority is a mandatory party to a proceeding which the plaintiff is unaware about, and he has filed the suit without that party being arrayed. Point it out in the written statement at the earliest. This will take the case in a proper direction. At the earliest, you may succeed in persuading the court that the plaint is defective. While I have stated about the pleadings, which is the first step and very important step in the litigation, please forget not that the plaint and the written statement, which you draft at the trial stage and you file it in the court at the first instance, will travel up to the end of the journey unchanged. And that will be the only and the strongest basis even for the Honorable Supreme Court, the High Court, or any other superior forum to address the issues and controversies and grant or refuse to grant the relief to one or the other parties in the case. So what you are writing today, what you're drafting today and filing it in the court is the basis and the foundation until Supreme Court, which may take few months, few days, or few years. So this is very essential. Now, the other mistakes that we commonly commit, and I'm sorry to call it a mistake, we employ that sometimes as an essential courtroom requirement. The advocate's skill will be sometimes gauged by the kind of things that we do in this fashion. But see, there might be a case where, along with the plaint, requesting the court for an interim prayer by filing an interlocutory application might solve half of the controversy in the case. It might save a long litigation. As it is stated in English, a stitch in time saves nine, it could be that we forget to make an important interim prayer at the initial stage, and that causes multiplicity of litigations later on. Therefore, choose wisely in all civil cases what interim prayer is to be sought for, at what stage the interim prayer is to be asked for, and immediately at the appropriate time file that application, interlocutory application, and ask for the interim prayer. So wisdom dictates to choose the right interim prayer at the right time. For example, if an interim order of temporary injunction or attachment before judgment are imminent and can save the party from imminent adverse effects, forget not to seek such interlocutory prayers at the most appropriate stages and times. You may remember sometimes the courts have framed one particular issue. The issue may not be fully appropriate, fully correct, or the burden in the issue might be cast on a particular party which it should not have. So please seek for modification of the issues framed in the suit at the earliest possible time. It might save a later noticed error. An amendment to the pleading, be on the facts or the reliefs, must be made at the earliest before the trial begins to avoid embarrassment at the penultimate stages of the litigation. For this, my dear friends, please remember what is very important is that once you draft the pleadings and file it in the court, and thereafter we assume that it is the duty of the court to frame issues, it is the duty of the parties to provide oral or documentary evidence and the list and the witnesses to come and depose. So we can be at leisure. No, this assumption that we can be at leisure until a later stage of the case comes out is not so appropriate for us. We have to be vigilant at every stage, on every date of hearing of a civil suit. We must brood upon, we must look into what has happened, what is to take place, what should have happened. Therefore, if an amendment would be required, if we take it very leisurely after filing the plaint and only at the stage of cross-examination of the witnesses of the opposite party, or at the stage of final hearing, if we look into the plaint and read it that time only, after a long lapse of time, we may then realize that we could have in fact amended the plaint to add or delete something very important. That would be too late for us to seek such a prayer. The court may not permit it. To avoid such situations, better we make amendments at the earliest, and therefore we read the brief every date of hearing meticulously, discuss this with the client, understand his perspective, we make him understand our perspective, then proceed with the case that day. Avoid filing in the interlocutory application at that stage of interlocutory applications. Please remember to avoid filing unnecessary, repetitive, incessant, unending interlocutory applications for every small thing. If there is a very, very small thing which you can give up and which can be ultimately done at a later stage, then don't file interlocutory applications. That is only going to elongate the entire process. That is going to upset and upset your client also, and derail the case from the main litigation. I would rather suggest that the suit should proceed to be determined on the main controversy rather than the parties be made to fight on every small stages of the case. Here I would remind to myself, not to you, the audience is quite wise here, but just to remind to myself, I have said, remember, the advocate is not only an officer of the court, but also the first point of contact for the litigant, from where the litigant gathers the general impression about the entire justice delivery system. No litigant must take home a wrong assumption that the courts can be taken lightly. If we are filing repetitive applications, incessant interlocutory applications, or being negligent at one stage and then making amendment application at later stages and are seeking the sympathy of the court, this attitude of the advocate may make the general litigant carry an impression which we should not allow. I'm very sure we haven't done, none of us here have done such things ever. Nonetheless, if there was a possibility of such a thing, it is better we have avoided, and glad that we are still avoiding it. client counseling, correction of pleadings, knowing the list of witnesses and documents beforehand is one important aspect of the case. Before finalizing the draft of the pleadings, ensure there is thorough client counseling. Generally, do not hurry in finalizing the pleadings. Give time to yourself and to the litigant to brood over what has been prepared before the pleading is filed in the court. Ensure the advocate understands exactly the same perspective of the facts and the rights that the litigant client is asserting. Let the client know the advocate's understanding of his case. Don't leave things to assumptions. Communication is the key for success. Many of the times it is seen the client required one relief and narrated the facts in one fashion, and the same is taken by the advocate in another angle. In the long run, it is realized that the beginning and the end of the case differ from its intent and purpose, serving no benefit to anybody. Don't finalize the draft without making appropriate corrections, be it typographical, grammatical, or on the substance and content. It is very natural in this profession to make repetitive corrections to the draft of the pleadings before the final version is approved for filing in the court. Remember, the pleadings filed in the beginning are the unchangeable basis for all subsequent courts, even the Supreme Court, to grant or refuse any relief. The quality of the advocate is first reflected in his pleadings, and the impression is carried right up to the High Court and the Supreme Court. Exercising abundant caution is a good habit. Perfection is an unmatched hobby, is what I may say. Today, we are taking the help of AI, artificial intelligence. There are certain applications, softwares which will help us in these kind of activities also. Nonetheless, still, I believe that we need to still make corrections to the drafts. Even if the AI is helping you people in giving the versions of your draft, you can still take your own time to make repetitive corrections and finalize it until you feel this is perfect for the requirement of the case. Discuss about the availability of credible documents, documentary evidence, and supportive witnesses before filing the pleadings in the court. This is very essential, my dear friends, that we take the information, the facts from the client, oral facts from the client, prepare the draft, file the written statement or plaint or the written statement, and later on, when it comes to the stage of proving those statements, we realize through the client that he doesn't possess a particular document or a witness is not available at all. And there we struggle in proving that the pleadings which we have made in the court. So strategically analyze the requirement of apt documents and witnesses suitable for proving the case. If the party is relying upon any document of title, ensure that the said deed is available with him, with the client, to be produced at the appropriate stage in the case. If a party wants to say, for example, rely upon a will or an adoption deed, ensure that the party is made aware that there is a requirement of the attesting witness to depose before the court. And it is mandatory and it will arise very soon. So when both the litigant and the advocate are on the same page, the same wavelength, and they both know the legal requirements of the case, the journey of the litigation will be smoother. We will not falter, we will not commit errors, because both the client knows what I want as advocate. I know what the client requires. Therefore, we will be in a better position to effectively render justice to the client. The next stage where we are required to take care and caution is evidence. Leading evidence in a civil suit also is equally important part of the strategy to effectively conduct the case. Like in any other criminal case, we should not forget this. We all assume that it is very important in a criminal case only the evidence part of the case. However, it is not so. Not only criminal case, it is also equally important in a civil case to concentrate on quality of evidence. To succeed in any case, the fundamental aspect of proof is, remember this, that without evidence, no amount of pleading alone can prove the case. Equally true is that without pleadings, no amount of evidence will be permitted by the court to lay any claim in a civil suit. So, evidence without pleading is not useful. Pleading without evidence is also not useful. Hence, equal importance is to be given to both pleading and evidence. Evidence which is oral as well as document. Therefore, it is necessary that oral evidence of all facts mentioned in the pleadings are deposed by the party and the witnesses concerned. Sometimes what we feel is we have the pleading anyway, why to repeat it? No. When we have pleaded, it is essential that the witnesses are required to speak about those facts pleaded in the plaint and the written statement, so that he will be ready for taking the questions in the cross-examination. Only thereafter, that becomes the basis for the court to assess and decide to grant or refuse to grant the relief. Common mistakes at the same time one commits is at this stage is to choose to lead the evidence. What we do is we choose to lead the evidence of a witness who is not very clear about the case and the contents of the case. We choose him unnecessarily, assuming that the more number of witnesses in a case, the more the probability and chances of succeeding. No, it is the quality of evidence rather than the quantity of evidence that is required for a court to decide the case. So we should be very circumspect while we are choosing to lead evidence of more number of witnesses than required. Documents that are unnecessary and tend to confuse more than prove facts could be avoided to be provided as evidence. Having a long list of witnesses and documents is not always the sure way to succeed in proving the case. Therefore, again, I repeat, continuous and meticulous monitoring of the case, reviewing the strategy, analyzing the developments at every date of hearing in the case at every stage is extremely important. Failing which, a good case might be lost sight of in a whisker. We might have a very good case, we might have prepared the pleadings well, but somewhere in the interregnum, we lose sight of that case, don't concentrate on that, don't revisit the strategies and analyze the case and the developments. And therefore, from that stage, we may lose the case. It should not so happen. Cross-examination is definitely another very important aspect of the matter where we commit mistakes. We all know cross-examination is an art. The skill of cross-examination is acquired only and only by actual practice. You may get some tips from reading books or from your seniors or somebody else, or your own thinking. However, you become effective in cross-examination only when you actually practice cross-examination in number of cases. Now, we must remember, as you all know, I'm only repeating here, you must remember asking all and only relevant questions is an ability developed by brooding about the brief, even when one is not reading the brief. Remember, friends, I have come across many advocates, and I also do it most of the times, that I might read the brief for some time, but I will think about the brief for the rest of the day, for the rest of the night, for several days and nights. It is only thereafter that I will be able to understand how to take it forward, what is to be done in the cross-examination, what is to be analyzed. So thinking about the case is also more important, as much as reading the case and the brief is important. When you are cross-examining a particular witness or a party, a variety of factors that you need to take note of, like the quality of the witness. I mean, uh, his educational status, or where he stands in the society, his personality as a whole, his temperament, his knowledge of the case, his keenness to support one side only in the case. Apart from many other factors, all these are required to be seen before putting questions to that party. Sometimes it is wise and smart, if needed, to take a break, a short accommodation, a short adjournment, to understand the case more deeply, to understand the witness more in a better way and in the right perspective, to be more effective. However, this should not mean that you must be unnecessarily seeking adjournments to uh, to unnecessarily drag the case. Remember not to ask questions that will dilute an admission which the party has already given in the cross-examination, or will invite burden, questions that will invite burden on your own party to prove anything unnecessarily. One should avoid, whether it is in the argument or it is in the cross-examination, it is more important what you don't ask and what you don't argue than how much and what you ask, or how much and what you argue. So remember, it is very important where to stop. And at this stage, I also am remembering that it is 7 o'clock. It is important that I should stop. Nonetheless, I will still take the liberty to keep this audience engaged for another 5 to 6 minutes, and I will conclude here. When a party gives an admission, do not ask more questions on that aspect, as the party might get alert and smarter to explain and dilute the admissions that he has given. So do not wander. Also, do not wander beyond the issues while cross-examining. If the party or witness was supposed to rely upon a document which he has failed to or forgotten to mark in the chief examination, do not direct your cross-examination in that direction. It is not to be confused with smartness, but it is being agile, vigilant, and relevant all the times during the cross-examination. I am not saying that you not asking a question, which will dilute an admission or take the attention of the witness to something which he has forgotten is smartness. I'm not saying you to be smart. I'm only saying that one has to be vigilant, has to be agile and relevant all the times during the cross-examination. It is said vigilance is a concomitant of effectiveness and professionalism. Now, preparation for arguments. Friends, this is very, very fundamental and rudimentary, which all of you practice, yet it is still beneficial to remember what we do and what is required to be done. Reading the brief thoroughly, even when one has read it several times earlier, is necessary at the stage of preparation for addressing final arguments or addressing arguments on any interlocutory applications. You may feel that I have already read the plaint or the written statement or the brief earlier, uh, some few dates of hearings ago. Nonetheless, one has to again read it thoroughly. Then, making written points handy in the file is justified unless you rely on your memory more than your notes. Few advocates lose ingenuity. They lose innovation if they make notes. Unless you are one among them or want to be one, so in future, prepare notes beforehand. Reading the whole deposition of all the witnesses is mandatory before preparation for arguments. Don't get alarmed. Friends, don't get alarmed to know that there are very senior advocates who have delivered lectures hours long on the topic how to make notes of cases. You can find it on several platforms. The topic is how to read brief, how to make notes, and very senior advocates have delivered lectures on this topic. So this is a very important aspect of one's preparation as advocate. We sometimes take it casually, rely upon our own strength more than what we should rely upon, and forget not to give importance to each and every case and not to make notes the way we make in some case which we feel is important. Sometimes one has to assume, remember friends, sometimes one has to assume with great respect that the judge is to be apprised of the most fundamental aspects of law and facts of the case. Do not hesitate to point out the same to the court. Sometimes it is wise not to repeat the aspects of law that the judge knows already. Don't irritate him also. I remember the words of seasoned advocates who said, no case is to be taken casually. No case is small or big. All cases are important. It is the work that the advocate puts in that makes a case and its outcome landmark. I am again extremely sorry to repeat these now stating rudimentary practices, but with this I will be concluding. But please have a look at it. Never lose your temper in the courtroom. Never treat your opposing counsel with disrespect. Respect his knowledge, skill, talent, and experience. The youngest and the most inexperienced, and the eldest and the most experienced, both exhibit qualities that need attention or ignoring for various reasons. Never meet your opponent or compromise on your integrity. Yet, never treat your client's opponent as your personal opponent or enemy. If the court has committed any error in its judgment or order, challenging the same before the superior forum as per the remedy available in law is the only legal and civic way. Do not offend the judge by your personal comments against the judge, either in the court or outside or in your chamber or in the presence of your client. After every order or judgment, remember, immediately communicate the same to the client. Find out the legal remedies to challenge the same. If a challenge is to be made, do it within the period of limitation. We commit mistakes at this stage also. Once we receive a judgment from the court or an order from the court, we stop at it. No, we must also keep track of what could be the next remedy, whether your party is required to go to the higher forum or will the other side go to the higher forum. What is the limitation? Should you appraise your client of this? Should any action be taken immediately to execute that or not? After you get an order from the court, if you have to execute it, please make an application for execution within the appropriate time. Take all steps necessary for implementing and enforcing the orders and the judgments and decrees of the courts. These are all small aspects of our daily routine work, which we sometimes don't take it very seriously in all the circumstances in each and every case, because of which in one or two cases we feel that we have committed that mistake, which we could have avoided. Therefore, I am repeating very, very small matters which are required to be taken with so much of caution every time. May I now, dear friends, take leave of all of you. I hope and assume that all of you feel enriched to at least go forward and take your time to look into these aspects of practice. Awaiting for the next session, if at all I am invited again. Thanks, one and all. Namaskara, Trivikram. Namaskar, Senior Advocate Chatratji. Thanks, others here who are keenly watching me. For any errors and mistakes that I have committed, kindly pardon me. Thank you.
Thank you, Michi. Session बहुत उमदा था, and people would actually enjoy it. And I've seen people are watching with great enthusiasm the YouTube. That shows the way you have expressed it. Everybody is cherishing it. Thank you, everyone. Stay blessed. And tomorrow we take the session by District Judge Mohan. The topic he's doing, as we all know, in respect of Indian Evidence Act, now PSA. I'm just sharing the topic with you.
We have got a lot of thank you messages. Thank you once again, sir. Thank you, Vikas, sir. Thank you, Amit, sir. Both senior advocates.
His sessions are always well received.
Yes, yes, very true.
Tomorrow is relevancy versus admissibility under the Evidence Act. Do join us tomorrow. Thank you, everyone. Stay safe, stay blessed.